Talk shoes. Recorded live.
Welcome, everybody. This is Matthew, and you are on our weekly Wednesday night call at 8 p.m. Eastern Time with special guest Christian Walters. And we are discussing NTT, New Trust Technology, which is making payments under trust and merging titles and extinguishing debts. Before we get started tonight, I'll read our notice acknowledging an agreement, and then we'll turn it over to Christian and get right into it. This show and our document is private and not construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. We will not use any of this information for making a legal decision or performing a legal procedure. It's not substitute for legal advice and or guidance by a licensed attorney. This show and or documents are for academic information purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing the show and or using the document therein, you understand an agreement. With agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind produced by non-attorneys or pro se parties in preparation of the use of the herein reference, or has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaison to communication between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and show recordings are incomplete and void without this notice agreement being attached here by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. All right, go ahead and mute everybody out and bring Christian on. Christian, can you hear us? I just unmuted you, Christian. Are you there?
Yes, I'm here. Can you hear me okay?
You sound great. Welcome to the call. The floor is yours.
All right. Thank you, Matt. Like Matt said, we left off on page 698 of the Lewin book under section 2, what creditors' deeds are revocable. And you might want to think of the word deeds as not being a piece of paper, but really representing an act that was done by someone. A deed is an act. And as we read this number 1 here, revoke irrevocable trust, keep that in mind in the sections ahead. 698, section 2, what creditors' deeds are revocable. Number 1, irrevocable trust. The existence of a debt is always a sufficient consideration to support an assurance as valid and irrevocable against the grantor. Indeed, the assurance will almost always assume the form either of a conveyance in satisfaction or part satisfaction of the debt, in which case the extinction of or partial extinction of the debt forms the consideration. I'm going to read that back again. In which case the extinction or partial extinction of the debt forms the consideration. Continuing on, or of a security accompanied with a forbearance to sue. Thus, if A be induced to B and convey an estate to him by way of security, the deed, though no money passes at the time and there was no previous arrangement, cannot be revoked by A, but B must insist on the benefit of it. And if the creditor be not a party to the deed, yet if by an arrangement between him and the debtor, the estate is vested in a trustee for securing the debt, he can enforce the trust, even where a debtor entered into an arrangement with 3 of his creditors and in persistence thereof. By a deed between him and part of the first part, the 3 creditors of the second part, and his other creditors of the third part, conveyed all his real and personal estate to the 3 creditors in trust for themselves and the other creditors. It was held that the intention was to make the creditors sedicii trust, and that the deed was irrevocable. And no distinction was taken between the 3 creditors and the other creditors, although the latter apparently had not been in communication with the debtors previous to the deed and had not executed it until some time afterward. Next section, number 2, revocable trust now. On the other hand, if a debtor without communication with his creditors, and indeed only for motives of personal convenience, as an ongoing abroad, vests an estate in trustees upon trust to pay his debts, the trustees are made mandatories, and the deed confers no right upon the creditors who are neither parties nor privies, and the debtor may at any time, at his pleasure, revoke or vary the trust, or call for the retransfer of the property. If the two persons have different interests in the same estate, and they by arrangement between themselves, but without communications with any creditor, convey the property to trustees, upon trust to pay the debts of either party, here, though they each may enforce the trust as against the other, yet the deed is revocable by both and the creditor, and as neither requires the security, nor was the object of bounty, cannot, while the deed remains revocable, compel the execution of the trust in his own favor. A fortiori, thus is the case of the payment of the debt to be made only to the request of the settlor. But of course, a trust cannot be revoked by the settlor so as to defeat or prejudice what the trustees may have done previously in due execution of the trust. Number 3, Gerard versus Landale, example of that. Gerard versus Landale, the Duke of York, by indenture between himself and the first part, trustees of the second part, and the creditors of the third part, conveyed certain property to trustees upon trust for his creditors, and upon execution of the deed in circular to that effect was sent to each of the creditors. Here was the ground for contending that, as the creditors had been induced by the notice to forbear suing the settlor, they had acquired a right to the execution of the trust. But Sir L. Shadwell, observing that the receipt of the circular was not admitted, and that if received, yet the creditors had not refrained from suing, and they had proved against the Duke's estate, decided that the creditors had no equity to enforce the trust. And the decree on appeal to Lord Brougham was affirmed. Continuing on, the authority, however, of this case has on several occasions been questioned, and Lord St. Helens observed he should be sorry to have it understood that a man may create a trust for creditors, communicate it to them, and obtain from them the benefit of their lying until perhaps the legal right to sue was lost, and then insist that the trust was wholly within his power. There can be little doubt that upon the general principles of equity, the settlor, by giving notice to the trustees and by subsequent conduct, may confer on the creditors a right which they did not originally possess. And indeed, it has now been decided that if the property be assigned to the trustee and he takes possession of it and communicates with certain of the creditors who express their satisfaction, the trust is irrevocable. Or trustee 1 of the creditors. If the trustee be himself a creditor, the debt forms the sufficient consideration on behalf of the creditor, and the deed is irrevocable. And in one case where the property was vested in a trustee for creditors and the trustee was surety for some of the debts, it was held that although the trust was revocable as to the general creditors, yet the trustee himself was not bound to recover the estate until suretyship was satisfied. 5. Nature of revocable trust. It does not clearly appear from the authorities that what is the precise nature of the revocable trust of this kind. The instrument is sometimes called a deed of agency, and if so, the trust must be considered at the end of which the death of the settlor and the property, so far as it has not been applied, must be administered as part of the settlor's assets. The trust is not regarded as revocable only during the life of the settlor, so as to give the vested interest in the creditor after his death, for it has been held that the creditor has no more equity to enforce the trust after the settlor's death than in his lifetime. 6. Voluntary trust. Suppose there's no fraud, but the trust deed is merely voluntary settlement, not founded on any arrangement with the creditors, or for a mere convenience of the debtor himself, so that it is revocable by the debtor at any time until communicated to some creditor. In that case, can a creditor taking out of execution, levy as debt upon the property subject to the trust. It seems though the deed is voluntary, yet as it is not considered as fraudulent within the statutes 13 Elizabeth, Section 5, and if so, the creditor cannot reach the property at law. However, the deed might perhaps be held to be invalid as against the creditor in a court of equity. Number 7, post-obit trusts. Post-obit trust. It has been doubted whether the doctrine of revocability extends to the case where the trust is to come into opposition only on the death of the settlor, and where subject to trust for payment of debts in the lands charged are conveyed by way of bounty to a third person, the presumption rather being that the creditors were also meant to be objects of the settlor's bounty. 8. Doctrine not likely to be extended. The courts of the present day consider the doctrine under these deeds being held revocable to have been carried far enough, and then express in disinclination to extend it as regards priority. And thirdly, what interest is to be allowed? First, what debts are within the scope of the trust? Number 1, debts to be paid are prima facie those at date of deed or death of testator. If the trust be created by deed, then unless the contrary intention be expressed, the debts only at the date the deed will be intended. But if the provision is be considered in a will, the direction will include all debts by the testator's death unless he is specially restrict his meaning to the debts at the making of his will. 2. Debts affecting the estate. Where a settler by deed conveyed all his property and real property upon trust to pay, quote, all debts then owing by him and which affected the estate thereby conveyed, unquote, the trust as the settler had no judgment debts at the time was extended to bond debts, but not to the simple contract debts. But this distinction was taken upon a deed dated before the acts making real estate's assets for payment of simple contract debts. Next, farther proving for the debt of son. In another case, the testator directed his trustees to pay £1,000 in releasing his son from his liabilities, should the testator not have done so in his lifetime. The son was an uncertified bankrupt, and the court, considering that debts subsequently to the testator's death were not contemplated, discharged his debts up to the period out of the £1,000 and gave the surplus to the testator's residuary legatee. 3. Debts barred by the statute of limitations. A direction for payment of debts will not revive a debt barred by the statute of limitations, though the trustee or executor may have advertised for all creditors to come in and prove their debts, and if the debt might be due diligence to be established, but there had been laches, which under ordinary circumstances would be a bar to relief, the mere fact that the creation of existence of a trust for payments of debts will not justify the laches and enable the claimant to obtain relief. But it will, maybe so specifically worded as to create a trust for creditors generally, notwithstanding any bar from the statute of limitations, for the debts still subsist through the remainder, though the remedy is gone, and if there be a debt in fact not barred at the date of the deed nor the death of the testator, the statute will not run afterwards. For it is not to be inferred that the man abandons the debt because he does not enforce payment at law when he is the trustee to pay him. Besides, unless delayed of necessity, the trustee ought to discharge his debt at once, and the universal rule is that the sedicee trust ought not suffer for the laches for the trustee. If the testator create a trust for payment of the debts of another person's deceased, then the debts to be paid are those which are not barred by the statute of limitations at the death of the person so deceased. Number 4, legacy duty. If a person who has been bankrupt direct payment of 20 shillings in the pound upon the debts proved in the bankruptcy, the creditors are legatees and pay legacy duty, but there is no lapse though the creditor will die in the testator's lifetime. 5, statute of limitations. Where testratrix had devised an estate to trustee upon trust to sell and pay debts, but no part of the produce of sale had been set apart for the purpose, the right of the creditor was held by the late V.C. of England not to be within the exception of the 25th section of the statute of limitations, number 3 and number 4, W4, section 27, but to fall into the 40th section. But that inasmuch as the debt had been acknowledged by the surviving trustee, the case was taken out of the statute. However, the opinion of the Vice Chancellor that the case was not within the 25th section would not, as it thought, not prevail, for the right of the creditor would subsist until the adverse possession had run against the trustee. 6. But not as regards a testator's personality. The rule that the creation of the trust keeps alive a debt not barred at the testator's death does not apply to the trust declared of a personal estate by will, for the personality invests in the executor upon trust for the creditors by act of law, so that the words of the will are nugatory, nor does the devise of a real estate upon trust to pay debts prevent the operation of the statute of limitations when the testator leaves no real estate to support the trust. 7. Debtor contracted by infant of necessities. The terms of the trust will extend to the repayment of sums of money borrowed by the settlor when an infant for the purpose of the necessities. 8. Cases of mortgages with covenant for payment. Shall a mortgagee who has covenant for payment for his debt be allowed to prove and receive dividend upon the whole amount of his pari passu with other creditors, or shall he prove only the excess of the debt beyond the value of the security, or what rule is to govern the case? In bankruptcy, the mortgagee proves only for the excess of the mortgage debt over the value of the security, so that he must first dispose of the estate with the concurrence, if he has no power of sale of the trustee in bankruptcy, or assets of value of it, and then prove for the difference. In the administration of assets in courts of equity, the mortgagee was until recently allowed to prove for his whole debts without being put on the terms of his security. But by the Judiciary Act of 1875, the rule in equity has been in insolvent estates has been assimilated to that in bankruptcy. The trust deed usually provides for the case of persons having specific liens, and engrafts the principle established in bankruptcy. If there be no such clause, and if the deed provided for the creditor shall release his debts upon securities for the same, the mortgagee, by executing the deed, binds himself to the other creditors, notwithstanding any private arrangement between the debtor and the contrary, that he will not take advantage of the specific lien, but will bring into the common stock and prove the whole debt, and accept a dividend pari passu with the rest. The moment, observed Lord Lyndhurst, the creditor releases the debt, which he does by executing a deed of this kind, there is, of course, at the end of the lien he may have for it. But though the word release be used in the deed, it will not necessarily operate as an absolute and unconditional release if the whole contents of the instrument, when taken together, show that such is not the intention. Number 9, trust for creditors who come within certain time. It was held by Dunch versus Kent that where it is for a trust for payment which the creditors shall come in within a year, a creditor who delays beyond the year is not therefore precluded from taking advantage of the trust. In Raworth versus Parker, B.C. Wood, after observing that there was no modern authority in which relief had been given after the time fixed for the execution of the deed had expired, added if it had been held that creditors are not admissible after the prescribed period, Dunch versus Kent must be overruled. And in a more recent case where the trust was for the benefit of the creditors who should execute or accede within 3 months, the Vice Chancellor held that the decision, which was affirmed by Lord Chancellor on appeal, that the creditors who had not accepted within the prescribed time might claim the benefit of the trust. 10. Adoption of deeds. It is not necessary that a creditor, to entitle himself to the benefit of the deed, should execute it, but it may be sufficient if he assent to it, or acquiescent in it, or act upon its provision and comply with its terms. But the creditor must do some act to testify his acceptance of the deed and not merely stand by it and remain passive. Number 11, disputed debt. If a trustee permit his person to sign the deed as creditor and the sum specified in the schedule, they cannot afterwards contest the debts. But where it has been a fraud, forgery, or perjury by the creditor, the trustee can apply to the court to have the execution by the creditor set aside. Number 12, trustee cannot arbitrarily admit the creditors who has repudiated the deed. The creditor who repudiates the deed by his acts, as by suing the debtor contrary to the provisions of the deed, will not be allowed afterwards, more particularly after a long lapse of time, to retrace the steps and take benefit of the deed. And though the trustee should admit him to sign the deed, and other creditors will not be bound by the acts of the trustees. 13, discretion of trustee to admit creditors' claims. If discretion is sometimes given to the trustee to admit or exclude such creditors as they shall think proper, the court will endeavor, if possible, to withdraw the rights of the creditors from the caprice of the trustees. But if the settlement clearly gives such a discretionary power and the trustees are willing to exercise it, and no fraud be found, the court cannot interfere to compel the admission of any particular creditor. 14, relief in equity. If the trustees have power of enlarging the time and advertise it to that effect, but do not exercise the power, and so exclude a person who desired to come in, but could not do so before the day named in the deed, the creditor will be relieved in equity. Now that equity just relieves about anything. It gets back to looks through the form, process, and procedure at the outlaw side and gets back into what the real substance is talking about. Number 15, resumption by trustees of possession after parting with it. If there be trustees for payment of the debts and legacies and subject thereto upon trust for A for life of the remainder over, and the court has taken an account of debts and legacies and declared A entitled to the possession who is put into possession accordingly, it is not competent for the trustees afterwards to make an admission of some further debt and to resume the possession in order to discharge it. 16, secret agreements. If the debtor agree behind the back of the general creditors to give an extra benefit to one particular creditor, such agreement is fraud upon the general creditors and illegal and void. Secondly, as to the order of payment now. Number 1, creditors paid before legatees. Where the trust is created by will and directions generally is for payment of debts and legacies. As regards of administration of assets, creditors take precedence of legacies, but here, as both taken under the will, the testator has made no distinction. It seems that upon simple principle, as was formerly held, that creditors and legatees ought to be paid pari passu. However, there can be little doubt that the testator, though he may not have been explicitly declared it, meant the creditors to precede, and the courts accordingly, rather straining on the point that a man might not sin in his grave, have now indisputably established that the creditors shall have the priority. Number 2, all creditors to be paid pari passu. As amongst the creditors themselves, the courts acts upon the well-known principle that equality is equity, and therefore, whether the trust be created by deed or will, the specialty debts in the absence of express directions to the contrary will have no advantage over simple contract debts, but all will be paid in ratable portions, and of course the trustees will not be allowed to break in upon the rule of equity or equality by first discharging their own debts. 3, specialty creditors. It was formerly ruled that where the testator charged his freehold estates with debts and the estate subject to the charge descended to the heir, the specialty creditor had precedence, for it was argued that he had his remedy at law against the heir independently of the will, and therefore ought not to be put on a level with those taking under the will. The answer is that the specialty creditor has no lien upon the estate, but can only recover from the debt from the heir personally to the extent the assets descended. If the estate is subject to the charge, the heir takes not beneficially, but only as trustee, and then there is no legal asset in consideration of equity, and the bond creditor has been enjoined from pursuing his legal right. And on these grounds, it has been decided that the specialty debts are not entitled to preference for cases of trustees being also executor. It is also thought that at one time, if an estate charged with the debts to be administered by the executor, the testator must have meant that the executor should, as an executorial capacity, observe the legal priorities. However, there was no reason, in fact, why the characters of the trustee and the executor should not be united in the same person without confusion, so it was since been determined. But where the trust is expressly to pay the settler's debts according to the priority, nature, and specialty, a bond debt with interest was payable before the simple contract debt. But now all debts of persons who have died on or after the 1st January 1870 are payable pari passu. Number 5, unclaimed dividends. If there be a remnant of unclaimed dividends left in the hands of the trustee, it is not belonging to the trustee of its own benefit, but will be divisible amongst the unpaid creditors who do claim. Thirdly, as to allowance of interest. Number 1, interest not allowed on simple contract debts. Where the trust be created by deed or will, and though the fund has been making interest, the trustee will not be justified in the paying interest upon simple contract debts not carrying interest, and a fortiori, thus the case where interest is expressly directed as to some principal debts, where the trust was by deed, but the creditors had not been made the parties. Lord Eldon observed, the mere direction to pay a debt does not infer either contract or trust to pay interest upon debts by simple contract. As to contract, the creditors did not execute the deed, and there was nothing to prevent their suing the debtor after the execution, and no consideration was given to the debtor by charging the land and discharging the person, even where the debts did in their nature carry interest, and the direction in the will was to pay the debts owing by the testator's brother at the time of his death, but 40 years had elapsed since the death of the brother, so that the interest, if allowed, would have been amounted to more than double the principal. The court thought the direction could not have been intended to include the interest as well as the principal. Number 2, the trustee does not make the debts specialty. It was once suggested by Lord Abinger that if a man executed a trust of the term for the benefit of his creditors, the deed makes them mortgagees if they execute it, and so gives them the right to the interest. And it was held in some old authorities, and even in a deed to which the creditors were not parties, or in a trust created by will for payment of debts, the creditors were to be regarded as mortgagees and were entitled to interest. But the doctrine in the later cases has long since been overthrown, and that is apprehended that the distinction taken by the chief baron cannot at the present day be supported. Again, it was said by Lord Hardwicke that if a man by deed in his life created a trust for payment of his debts, annexes a schedule of some debts, and creates a trust term for the payment, and that is the nature of the specialty, it will make these, though simple contract debts, carry interest. But this dictum is not in conformity with the law as now established and cannot be maintained. Number 3, Pierce versus Slocumby, where A and D assigned their joint property to C, D, and E upon trust, in the first place to pay the joint debts at the expiration of a year from the date of the assignment, and then as a moiety and pay the separate debts of A, and the end of a year sufficient assets were realized to have discharged the joint debts, but the money, instead being so applied, was invested in the funds and the interest accumulated. It was held that as the funds applicable to the payment of the joint debts had been making interest from time to time, the debts should have been paid. The joint creditors, though the simple contract, were entitled to interest at 4% before the separate creditors were paid their principal. The separate creditors would otherwise try otherwise try to impede the general settlement in order that, in the meantime, they might enjoy the interest from the joint creditors' fund. Number 4, creditors may stipulate for interest. Creditors may stipulate for payment of interest, or the settlor, if so minded, may insist on such a direction. But a trust for payment of specialty and simple contract debts and all the interest thereof will not amount to such a direction, but the words will be taken to have referenced the debts carrying interest of their own nature. 5, specialty debts. Specialty debts, though actually released by the creditor's deed, will carry interest up to the time of payment. It might be urged, indeed, that the regard specialty debts the amount of the debts and the principal interest, and therefore the trust for the payments of debts interest as well as the principal must be taken into calculation to ascertain the debt as it is at the date of the deed or the death of the testator, but that interest ought not to run beyond the date of the trust deed or the death of the testator, for that principal and interest together are then regarded as one sum, not as a debt but the claim of the Sedekey trust. And some principle of this kind appears to have been enacted upon the case of Carr versus Burlington, where a person vested estates and trustee upon trust to pay all the debts as he should owe at his death, and the court directed the master to calculate the interest on such a debts as carried interest upon the death of the settler, but the master was not to carry on any interest on any security beyond the settler's decease, but were a case where the assets to pay the simple contract debts as well as the specialty debts, the question of ulterior interest was reserved. At the present day, however, the rule is considered a specialty debt as subsisting up to the time of the payment, that is to calculate the interest on the principal not only up to the date of the deed or the death of the testator, but up to the date of payment. 6, bond creditors not entitled to interest beyond the penalty. Bond creditors, it must be observed, will in no case be entitled to receive more for principal and interest than the amount of the penalty. Might want to go back and review that section. Next section, Chapter 21, the duties of trustees of charities. For 1, charities by either being established by charter as mulcenary corporations or may be placed under management of individual trustees. 2, charities by character. Before entering upon the duties of the trustee for charities, it may be proper to introduce a few preliminary remarks upon the subject of the court's jurisdiction over charities established by charter. Number 3, visitor. On the institution of such charity, a visitatorial, that's a mouthful there, visitatorial jurisdiction arises of common right to the founder, whether the Crown or a private person, or to whom the founder has substituted the place of himself, and the office of a visitor is to hear and determine all the differences of members of the society amongst themselves, and generally to superintend the internal government of a body, and to see that all the rules and orders of the corporation are observed. The visitor may take at his guide the statutes originally propounded by the founder, so long as he does not exceed his proper province. His decision is final and cannot be questioned by way of appeal. 4, jurisdiction of the court over corporate bodies. With this visitatorial power of the court has nothing to do. It is only as respects to administration of the corporate property that the equity assumes to itself any right of interference. Informal elections, maladministration. Upon the ground of this distinction between the visitatorial power and the management of the revenue, any information of the removal of governors or corporators as having an irregular appointment would be dismissed with cost, but wherever the administration of the property by governors can be shown to have a tendency to prevent the end of the institution, the court will immediately interpose and put a stop to such wrong application. Number 6, how property newly given is affected by visitatorial power. The estate newly bestowed upon an old corporation is not to be regarded in the same light as property with which a charity was originally endowed. The visitatorial power is forum dominis dictum, the private jurisdiction of the founder, and a new gift will not be made subject to it unless the will of the donor be either actually expressed to that effect or is to be collected by necessary implication. If the legal or equitable interest be given to the body corporate and no special purpose be declared, the donor has plainly implied that the estate shall be under the general statutes and the rules of society and be regulated in the same manner as the rest of their property. But if the particular and special trust be annexed to the gift, that excludes the visitatorial power of the original founder, and the court, viewing the corporation in light of an ordinary trustee, will determine all the same questions that would have fallen under its jurisdiction had the administration of the fund been entrusted to the hands of the individual. Number 7, private foundations with charter. Where a private person founds a charity and then the Crown grants a charter, the presumption is that the Crown meant to carry on the founder's intentions, and the jurisdiction of the court which existed before will be continued. 8, cases where the visitatorial power may be exercised by the Lord Chancellor. Even the visitatorial power may, under the particular circumstances and with a special manner, be exercised by the Lord Chancellor, for the Crown may be visitor by the terms of the foundation, and if the error of the founder cannot be discovered or become lunatic, the visitatorial power, rather than at the corporation, should not be visited at all, will result to the Crown. And while in civil corporations the Crown is visitor, though, the High Court of Justice, for the corporate bodies which respect the public policy of the country and the administration of the justice are necessarily better regulated under the superintendence of the law of the court. Yet as regards involuntary corporations, the Crown's visitatorial power is committed to the Lord Chancellor as a matters of charity or more appropriate supervisor, and the mode of application of the Lord Chancellor in all these cases is by petition to the Great Seal. We now proceed to the consideration of the duties trustees of charities. Number 9, fund must be applied to the charity prescribed. It is, of course, imposed upon the trustee, where the individuals or a corporation, not to convert the charity fund or other uses then according to the intent of the founder or donor, so long as those uses are capable of execution. Thus, if a gift be to find a preacher in Dale, it would be upon breach of a trust to provide one in sale. But if it be to find a preacher, it would be a breach of trust to apply it to the poor. If the trust be for the poor of O, it would be a breach of trust to extend it to other parishes. If the trust be to repair the chapel, the rents must not be mixed up with the pro rate for parochial purposes. If the fund be raised for erecting a hospital, it cannot be diverted to lighting, paving, and cleansing the town. Number 10, chapel for schools. A chapel was granted to trustees for a school and the use and benefit of the said school, and though the inhabitants of the hamlet had long been accustomed to attend divine services in the chapel, it was held that the chapel was for the exclusive benefit of the school, and the trustees had no power to apply the revenues of the charity towards enlarging the chapel for the better accommodation of the inhabitants. Number 11, chapel pulled down. The trustees, for maintaining a chapel, had pulled down the edifice, converted the burial ground to profane purposes, and carried on the bell to the marketplace, but the pews in the parish church, and employed the stones of the chapel for repairing the bridge. Sir T. Plummer said it was an enormous breach of trust, and such should not have been expected that the Christian country, and directed an inquiry to the monuments, had become in the hands of the trustees on account for the breach of the trust, and would be to the expense of restoring the chapel to the state in which it stood at the time of the destruction. Sounds like what we could do. Since they've destroyed our trust, so to speak, we could come back and use the same principle to restore our trust. Number 12, charity on aid of rates. A fund in aid to the relief of the poor citizens who often were generously burdened by the impost of taxes of the city was held not to be applicable to the payments of rates and other expenses of the city that would otherwise have been raised by public levies and impositions, nor to be destructible to such of the poor as revised parish relief, for it would be so much in aid of the ratepayers, but ought to have been administered for the exclusive benefit of the poor. 13. Poor of the parish. Where a trust was created for the poor of the parish, it was for a long time doubted that the class of persons was entitled to the benefits. Lord Eldon thought that the fund should be administered without reference to the parochial relief, for assistance might have been given to the pauper without exonerating the rich from their usual contributions to the rates, and to the relief which the law had provided, further relief might be added, which the parish had not bound to afford. Besides the appropriation of the fund to the poor, not in receipt of the parochial relief, might still have the effect of conferring the benefit on the rich, for the person who could not otherwise have maintained themselves might, by means of the charity, be prevented from seeking assistance from the rate. However, it was determined in several cases that it seems, therefore, it has now been settled that the charity must be confined to those not in receipt of parochial relief. 14. Trust for maintaining the worship of God. If a land or money be given to maintaining the worship of God or the promotion of godly learning, and nothing more is said, the court will execute the trust in favor of the established form of religion, and dissenters cannot be appointed trustees. But though the trustees of Church of England school must be members of the established church, it does not follow the children of the dissenters are not to be admitted into the school, or even that the master may not be a dissenter, though the latter appointment could only be justified by peculiar circumstances. If it be clearly expressed upon the deed or will that the purpose of the settler is to promote the maintenance of dissenting doctrines, the court, provided which doctrines to be not contrary to law, will execute the intention. 15. Numerous contributors. Where a fund has been raised for the purpose of founding a chapel and any other charity, and the contributors are so numerous as to preclude the possibility of all their concurring in any instrument declaring the trust, and a declaration of trust was made by the persons in whom the property was vested at or at the time about the time when the sums were raised, that declaration may reasonably be taken prima facie as a correct exposition of the minds of the contributors. 16. Trust originally intended will be preserved. Where an institution exists for the purpose of religious worship and it cannot be discovered from the instrument declaring the trust of what form or species of religion worship was in the intention of the settlers, the court will then inquire what has been the usage of the congregation, and has been the usage and if such usage do not contravene public policy, it will be guided as it has evidence of the intention of the administration of the trust. And by 7 and 8 Victoria, Section 45, subsection 2, if the instrument of trust do not in express terms or by reference to some book or other document define the religious doctrines, 25 years usage immediately preceding any suit is made conclusive evidence thereof. But if for the purpose of the settlers appear clearly upon the instrument, the court, in that case, though the usage of the congregation may have run in different channel, cannot change the nature of the original institution. It is not competent for the majority of the congregation or for the managers of the property to say, quote, we have altered our opinion, and the chapel in the future shall be for the benefit of the persons of the same persuasion as ours, unquote. Appointment of new trustees. The deed of an endowment neither provide for the succession of the trustees nor the election of a minister. An inquiry will be directed who, according to the nature of the establishment, are entitled to proposed trustees, and to elect the minister. And if the election of the minister properly belong to the congregation, the majority is for the purpose of the congregation. The appointment of a minister cannot, in such case, belong to the heir of the surviving trustee, who may not be of the same persuasion, but it might happen a Roman Catholic or Jew. Notices. For the valid election of a minister, due notice of the meeting for the purpose must be given, and no person must take part in the proceeding who are not entitled to attend. Sounds like RSVP. 18. Minister of a meeting house. A minister in possession of a meeting house is tenant at will to the trustees, and his estate is determinable by demand of possession without any previous notice. But this merely tries the legal right without affecting the question whether in equity the minister was properly deprived, and if the minister be in possession and preaching the doctrines that were intended by the founders, it is the practice of the court of equity to continue him until the case can be heard, whether it was duly elected or not. For the first point is to have the service performed, and the court will pay him his salary. If a minister be removed by the decision of the congregation regularly convened at a meeting, and charges intended to be brought against the minister must be specified in the notice calling the meeting, and the minister himself must be apprised of the nature of the charges. 19. Minister may be removed at pleasure. It is a policy of the established church by giving the minister an estate for life in his office to render him in some degree independent of the congregation, but if it be the usage amongst any particular class of dissenters to appoint their ministers for limited periods or to make them removable at pleasure, though the court of equity might not struggle hard in support of such a plan, it is in no principle upon which the court would not be bound to give it effect. And accordingly, where a decided majority of the congregation passed a resolution to the removal of the pastor, a court granted an injunction against his officiating. 20. Original intention cannot be defeated by bylaws. To every corporation there belongs a common right of the power of establishing bylaws for the government of their own body, but this privilege cannot authorize the enactment of any rules or regulations which would tend to prevent or destroy the directions of the original founder of the objects of the charity. And so a clause indeed investing the trustees, or a major part of them, with the power of making orders from time to time upon matters relating to the meeting house would not enable them to convert the meeting house, whatever they thought proper, into a meeting house of a different description for teaching different doctrines from those of the persons who founded it and by whom it was to be attended. 21. Mistake. It is not a custom of the court to remove objects of a charity who have been elected under a mistake, where election was bona fide and without any fraud or corruption. 22. Act of Parliament necessary for the purpose of changing the trust. A charity fund cannot be divided into a different channel without authority of Parliament, either directly by a special act or indirectly through a charity commissioners, who are now empowered to approve provisionally of a scheme varying from the original endowment with view to submit to the Parliament for its sanction. 23. Expenses of an act. Formerly, trustees, before applying to the legislature, were in the habit of procuring the sanction of the Court of Chancery for their greater security. For if they took such a step upon the mere suggestion of their own mind and failed in obtaining the contemplated act, they were not allowed to the costs and expenses incurred in the proceeding, but if the application of Parliament was attended with success, the trustees were then allowed their costs, though the sanction of the Lord Chancellor had not been previously obtained, for the court could not with propriety pronounce those measures to be imprudent, which legislature itself had enacted as prudent. Letter may be broken and yet the spirit preserved. Management of a trust may contravene the letter of the founder's will and yet on a favorable construction be conformable to the intention. Free Grammar School. It was the opinion of Lord Eldon and Sir T. Plummer that if the wish of the founder was to establish a free grammar school, the Chancellor, though felt perfectly convinced that the free grammar school, that is a school for teaching the learned languages, could be of little or no use, would yet be bound to apply the revenue as the donor had directed, and could not substitute a school for teaching English and writing and arithmetic. It has been since held by the Lord Lyndhurst, Sir John Leach, Lord Langsdale, and Lord Cottingham that the court has jurisdiction to extend the application of the charity fund for purposes beyond the literal intention, and that the writing and arithmetic will be well induced into the scheme for the establishment or better regulation of free grammar school. Free school. And thus many of the courses be done in the case not of free grammar school, but of free school. 3 and 4 Victoria, Section 77. By 3 and 4 Victoria, Section 77, the system of education in a grammar school is extended to the other useful branches of literature and science, in addition to the lieu of the Greek and Latin languages, or such other instructions as may be acquired by the terms of the foundation or the existing statutes. Now, you might want to think about this, how this applies to our schools today, since they are deficient in certain areas but not teaching the law any longer, and how it could be applied to where now that could be changed. Continuing on, 25, 32 and 33 Victoria, Sections 56. By the Endowed Schools Act of 1869, that's Section 32 and 33 Victoria, subsections 56, the commissioners appointed by Her Majesty to inquire into the schools were empowered by Section 9 in such manner as to might render any educational endowment most conducive to the advancement of education, to alter and add to any existing, and to make any new trust, direction, or provisions in lieu of any existing trust, direction, and provisions. But by Section 14, the Act was not to apply to charities created less than 50 years before the commencement of the Act, unless the governing body of the endowment assented to the new scheme. By 37 and 38 Victoria, Sections 87, the powers of the endowment schools commissions had been transferred to the charity commissions, and certain amendments of the law have been introduced. 26. London Parochial Charities Act. By the City of London Parochial Charities Act 1883, the Charity Commissioners are empowered to inquire into the nature, tenure, and value of all the property and endowments of certain parochial charities of the City of London, and to prepare schemes for the future application and management of the charity property and endowments. But by Section 21, no scheme is to affect any endowment originally given to the charity into charitable use unless than 50 years before the commencement of the Act, unless the governing body assent to the scheme. By Section 39, power is given to the commissioners to direct the sale of any part of the charity property upon such terms and conditions, and to such purchases as they may think fit. And the trustees for the time being of such property are therefore thereupon to effect such sale. By Section 48, a new corporate governing body, also to be called the Trustees of the London Parochial Charities, is to be established with perpetual succession and a common seal. I think we'll stop there, beginning on 27. Ejectment of person ceasing to be schoolmaster, beginning on page 731. We'll begin there next time. 731.
731.
731, number 27.
Alrighty. Now, if we look at the calendar, Christian, for next week, just to be aware of everybody, the holidays and everything. What is next week? Next Wednesday, the 27th, is the day before Thanksgiving. I would think a lot of people would be traveling. So should we?
This is 24th next week?
Today's the 7th. No, okay. What is today?
17th.
Today's. Oh, I'm looking at. No wonder I'm looking at October. Okay. 24th.
Thursday must be the 25th. That's Thanksgiving.
Right. So should we take a Thanksgiving recess next week, do you think? Because most people will probably be traveling. I know we're the day before Thanksgiving is the heaviest travel day of the year. I'm just throwing it out there. We can certainly do it, but I'm not going anywhere. My family's all in town here.
We might as well just do another night. You know, it's up. You know, it's okay with me. I don't care. You know, I mean, we could. They could get the recording and listen to it.
Sure. Sure. No, I just thought I'd throw it out there. Not a problem. All right. Well,
I don't have any mind on it, so if you don't.
I'm okay with it.
Okay. Well, let's just go ahead and do it. Anybody's traveling, just get the recording and listen to it.
There you go. Well, we got our first caller. Are you out there, Darren? You're unmuted.
Hey, Christian, how are you?
Hi, Darren.
How are you? I wanted to tell you, it was interesting. I was looking up a file for a guy. He wanted me to help him with discovery on some of the cases. And, of course, some of the Paramount cases, even though this is at the at-law side, was like Brady v. Maryland. There was one interesting case which I found the verbiage totally spell out relief. It was under the Hazel Atlas Glass versus Hartford Empire, 1944. And an excerpt from that, it said, every element of the fraud here disclosed demands the exercise of the historic power of equity to set aside fraudulently begotten judgments. I thought, wow, right there, there's relief and equity right there.
Yeah, that's the second division of equity.
Right, now here's also the
division being fraud, mistake, omission,
suppression of evidence.
Yeah, lack of performance. Yeah.
Okay. Now the interesting thing is, of course, when we're on the equity side, we can't quote case law because that brings us back over to the D.C. side. But can't we use even the verbiage of a specific case without citing it into our equity pleadings somehow, or even into judicial notice?
Yeah, I suppose you could, as long as you didn't specifically cite it, I guess.
Yeah, because really, I mean, you think about the language like right there of what it's stating, and it goes back to exercise the historic power of equity, which now you're going clear back to England. And it says to set aside the fraudulent begotten judgments. To set aside is not where you're going after damages which can't be met, but for the relief from that judgment is also in the power of equity, so there you go.
Yeah, I think that all the case precedents out there since, well, maybe even since before, all case precedents, period, are really derived or tied back into some one of the, say, 12 maxims out of equity. Everything comes back to that. All the laws got to come back to that. So
yeah, because
if you find a maxim that applies, quote that with it.
Because really, though, even at the at-law side, what is founded on that side is more of a privilege, but it's kind of mirroring the real law, which is the senior claim in equity, where you're invoking a right.
Yeah, and where everything is equal, fair, just, and right, which is, you know, your 12 little crutches, say, are your maxims that get you back into a God-centered mind.
Right. Yeah, but I found that case really interesting. I forwarded it over to your wife and a few of the TAs. I just found the verbiage very powerful in regards to it just spelled out the relief, the whole part of it.
Yeah, that points it back to equity. But then I think if we come back in now equity, which one of the maxims in equity applies to what they're talking about? and we had a thorough knowledge of how they comported back and how it transitioned into the law, then in fact we've got a diamond jewel, because you can remember 12 maxims.
19.
I don't need 63 million laws plus.
No, but there's 19 maxims.
Yeah. Okay.
I think there's more than No, but there was the one that says is that what is it? A right or relief will not be cloaked by the fraud of a statute, similar to that. The language, something like that. I'm just doing it off the top of my head without looking.
Well, that comes in beautifully, because then that negates your at law side, because you want equity.
Exactly. Okay, I just thought I'd share that with you on that. So that was about it.
Yeah, we're going to do a study on these maxims a little more, but I've been hitting it out there as people start, prepping for it.
Sure. Okay, that's the only thing. I thought that was a really good show last night, and it really, really clicked in last night how that was associated. Now I saw things so differently, and really to make it easy for everybody, and everybody, especially where everybody's been on the at-law side, is where anytime there's an allegation, of course, that is an NOI, but it has to be supported by an SOI, and if not, then it needs to be stricken or quashed, especially if you're like on the defendant side, or even vice versa. If you're on the plaintiff side, any NOI, you have to have the burden of proof to substantiate it with an SOI.
Yep. That's what I've been talking about all along.
Sounds good to me. Okay, that was it. That's all I got.
I think it was probably better brought out last night than anything else.
See the difference one man makes?
Yeah.
Just playing. Okay, that's it. That's
it was like we spent months and months and months hammering the doctrine in, but then, it finally got to a point to where now, although we were explaining it before, but I don't think people were grasping it. Until finally we got enough doctrine hammered into somebody that we can start, saying, okay, here it is. This is what it is. This is what,
And I'll be the first to raise my hand on that one, because the thing is, I have been so trained on the debtor-creditor side for so many years, and to learn it, it's actually it's like a biblical principle. You got to renew your mind. And finally, it's all clicking in and not only making more sense and simpler, but the fact is, you got to remember, in equity, it's a senior claim versus the at-law side.
Yeah, I would stress the word simpler.
Well, in a sense, once you know the foundation and you know the process and procedure in structuring your elements, is in regards to creating the titles, exchanging them, redepositing them, creating the indenture, writing an agreement, which is basically your special orders and your duties, how the trustees to perform, and then the procedure once you get into court, and now you have to establish your bill in equity. Now it's a matter of the burden of proof that you have to show the judge, hey, here's what I got here. Here it is. Of course, you don't recognize it because I can't disclose it here. Let's go into chambers, and I'll let the cat out of the bag.
Yeah, because really everything the judge is saying should be taken advantage of and turned around, and that was the invitation to give your evidence.
But it's simpler. I'm just telling you, years and years and years on the at-law side, it's simpler. I won't tell you how long it took me to just, go through everything on that at-law side in regards to studying, reading case law, rules, procedure. And you have so many different rules on that side. You got judicial rules, you got rules of civil procedure, you got rules of evidence,
right.
Then the statutes, the laws, and, thank God for the lesson, because now I have that same mindset where I could take it on the equity side and going, hey, this is a lot more simpler, because the courts still operate on form and procedure whether you're on the at-law side or on the equity side, it's still based on rules. So there's still rules that the court has to operate by. It's just like when you have a computer program, you have to tell that program what you want it to do. The courts work the same way.
That's the key. You tell the program what you want it to do. That's the same way here. You invoke which side of the court you want.
Absolutely.
But the key is you got to do it by how they set it up to throw the switch, and that might not be quite figured out how the right key to get it in there. But you still control whether you want the at-law side or you want the equity side. It's just a little bit hidden because, you know, the key has to be made just a certain way in order for it to work.
But I really think you'll get some eyebrows turned in there bringing in an equity action because I do believe the judges will say, you know, he's got a superior claim here. Now, you might
and
get
if you don't give up on the lower courts and continue on, take it into an appeal, and then have a good, strong case to begin with, and then it's going to get handed back down to them. And, you know, if we take it to appeal and we get enough of them handed down, they're going to start paying attention and say, no, hey, we can't have these up on appeal anymore. So they're going to do it right.
Right, because the thing is they're going to look at and they're going to go, are they on point? Are they on point on everything, on their procedure? Are they on point on their process? Are they on point on their forms? And are they on point on the rules?
Yep.
Okay, that's it. That's all I got to say. That's my story, and I'm sticking to it.
All right.
All right, thanks.
All right, thanks,
Darren. Folks, if you got a question, you want to raise your hand, ask Christian a question, hit *8 on your phone, and it'll show up on my screen. I can unmute you. *8. Anybody got a question, folks? It's *8. I wonder if it's going to be a short night tonight, Christian.
Yeah. Maybe everybody left for Thanksgiving early.
Here's our next caller. Let's see if I can get him here. Zyq, did I say that right? You're unmuted.
Hello.
Is this Don?
Yes, this is Don. How are you, Christian?
Okay, good.
Hey, we've been working on our paperwork for going to court on Friday. We putting together our list of questions to ask the question or the attorneys when we want to have them come in and testify. Have you ideas what kind of questions would be appropriate to present to them?
Let's see. I gotta get my mind in gear to what we were talking about. Can you kind of backtrack for me?
Well, as you know, we had our hearing on Tuesday with the bankruptcy case, and the case was continued till Friday.
Right.
So Friday becomes Doral's turn to speak, and he gets to ask questions, or he gets to bring forth witnesses, or he gets to depose, I guess, the other attorneys, because they're going to be acting as witnesses. Well,
if the attorney is testifying on any subject matter, he can't testify. Yeah, that one's an easy one. If they're talking about anything that's not in the pleadings quoted directly, they can't speak anything that's not in their motions. Because, number one, they're not a competent first-hand witness. They're not competent witnesses.
Uh-huh.
They don't have first-hand knowledge. And they can't speak anything that's not in that pleading. And anything else you can object to and say, that's hearsay.
So it wouldn't be necessary to put them on the stand and ask them questions?
Well, yeah, you could. Here's another thing. You might want to put it in a motion in limine and limit them to only sworn and verified affidavits and testimony and pleadings.
Huh? Okay. Hadn't thought about that one.
Yeah, any attorney can't speak anything other than what the plaintiff has written down in the motion. Because only the plaintiff can speak, and if the plaintiff isn't there and the attorney's the only one there, then the attorney can't speak anything other than what's in the paperwork. And you can object to anything else that he says outside the paperwork as being hearsay, because he's not a competent fact witness. Ask them, can you swear as a witness on a witness stand that you have firsthand knowledge to what you're testifying?
Right.
Because if you are, I want to swear you in, and I want to know who's going to hear the case, because you're no longer an attorney, you're a witness.
Right. Now, can we put them on the stand and ask them questions about their motions that they put in?
Yes, if they say they have firsthand knowledge. Now, if they don't have firsthand knowledge, then I would be objecting and motioning to strike what they're giving testimony of.
Mm-hmm.
Because they're not competent firsthand witnesses, and there is no firsthand competent witness here, because plaintiff is not here.
Right. So we're trying to formulate our strategy here, trying to figure out what might be the best way to approach that.
Well, as soon as one of the attorneys starts opening his mouth up, and I would be objecting and asking, where was that in the pleading? Where are you reading from? What are you talking about? Because if it doesn't contain, if it's not contained in that pleading, then that's the only thing you can say or speak about.
Mm-hmm. Well, in one of the motions that was to be discussed was the motion that the attorney for ADF&A had put in for strict compliance. And within that motion, he calls the owners of the store the trustees, who are supposed to collect the taxes and remit them to the state. Is that not an implied trust?
Might be. Might be. They're not claiming a trust, or are they?
Well, if you're calling him a trustee, is he not claiming a trust?
Okay. Well, if they're saying he's a trustee, then yeah, okay. They're claiming there's got to be a trustee. There's got to be a trust, so they got to be claiming there's a trust.
That's what it's called in the pleading.
Yeah, because he who makes the claim for anything, whether it be trust or otherwise, has to prove. Now, where's the proof?
Mm-hmm. Well, that's the thing. The pleading has no attachment, so there's no proof that there's a trust. He's just making the statement that the trustee is supposed to collect the money and give it to them.
Well, that's where I start objecting and say that his claim is unsubstantiated. Where's the record? Show me the record.
No SOIs. Okay. Any other questions? Well, okay, I think that's all the questions I can think of at the moment.
Okay.
Still trying to work on this.
Those are good questions.
Thank you.
Next caller, San Gretagrado. You have been unmuted. Go ahead with your question.
Hey, good evening, Christian. This is Dan. How you doing?
Hi, Dan. Good.
Great. My question was, it was a great call last night, and was looking back over some of the reasons that are used for a motion to strike or a motion to dismiss. One of the reasons for a motion to dismiss as an affirmative defense is a court lacks jurisdiction over the subject of the case. Let's say, for instance, you're being sued at law for a breach of contract, but you've gone ahead and done all your NOIs, your SOIs, you've got an indenture, you've got everything in place. And is it possible to file a motion to dismiss because the subject matter of your issue is in equity and not at law?
Yeah, that's what I was just going to say.
Okay. Maybe that would be a good way to knock out a plaintiff coming after you prior to you filing, say, a bill in equity or taking an offensive position using trust. If there's folks out there that are in that kind of that limbo stage, you're not quite there at enforcing your trust, but you have the trust in place that the law will recognize as a trust.
Yeah, that's possible to do that. Yeah.
Okay. All right. Well, that's pretty much all I had. Great call last night. That was
especially if there was no sworn affidavits, no evidence attached that's verified, and there is no verified pleading.
So usually you'll get
and there is no evidence to support even an at-law claim, let alone the fact that you've got an equitable one. And most of these pleadings that they put in are not verified. All they have is copies, which are copies of hearsay. They're not sworn to or verified, and there are no affidavits in support of any testimony given by anyone. So their whole complaint is frivolous, let alone the attachments.
That seems to be status quo. A photocopy of a DC contract, barely legible, and
yeah, but if we don't raise issues of jurisdiction, then we waive it. And although jurisdiction can be challenged at any time, that's one you really can't waive. But if you don't bring it up and challenge it, then in effect you've waived it.
Because I'm thinking if you challenge jurisdiction, maybe the judge would order, maybe you could get a hearing scheduled to have the judge look at your trust documents and let him say, oh, okay, yeah, this is correct. This is not an outlaw jurisdiction. This is an equitable one. And
you'd have to have first we'd have to have an equitable counterclaim or a bill in equity put in.
Hmm.
If you didn't, the case has already been set for the at-law side, and you got to come in with the counterclaim being a bill in equity to reset it as equity. And then your counterclaim should be heard first before their at-law side, and if not, well, there's a violation there then.
So then do a motion to dismiss, and then immediately follow that up with your bill in equity as a counterclaim.
Well, you could do a motion to dismiss, but really your counterclaim should be heard first. And if my counterclaim also included a stay, because I think it's at 3790 and the Institute of American Law by Bouvier. It says in there the stay of the at-law side is something that must be granted.
Mm-hmm.
3790 in the Institutes of American Law by Bouvier, Volume 2, 3790, it says the stay at law must be granted if you have an equitable claim.
All right. I got that in my notepad. I'm trying to memorize these things. If you can commit that to memory, that's pretty handy weapon to pull out when you're on the spot there in front of a judge or whatever. Good way to volley the ball back over the other court. Now, in your original bill, in the in your caption, as far as what you're looking for, breach of trust, breach of trustee duty, injunction, whatever. Do you think it'd be wise to put in constructive trust as well? You're looking for the judge to construct a trust?
If you're going to be talking about tracing and all that, yeah, possibly.
Okay. So I got original bill in equity for breach of trust, special injunctive relief, stay of legal action, and then going back over Gilbert's and an equitable claim by beneficiaries is one of the remedies, or one of the relief is the constructive trust to compel specific performance or the return of trust property.
Yeah, but let's not forget the proof of the trust, being the most important part. Once it's proved trust, then we can go on to the other stuff.
Right.
Or a stay before the proving of the trust. Let's put it that way. That way you can get a stay first, that everything stops until you can come in and have your trust hearing for proving the trust.
Right. Well, if you can get the maybe in an equity memorandum or something, we could reword or perhaps state all of the trust test elements on page I.
Yeah, the way I see it, there's two things happening. Either we need to shore up what we're doing at the very beginning, and it's laying a better foundation leading up to the proving of the trust, or else they're bluffing.
Right.
One of those two. And if they're bluffing, that really is going to cause us to shore up and make our petitions the best we can anyway, which is really going to strengthen our position. And then if we take it through onto an appeal, then we're going to find out whether or not they're bluffing. Because if it gets remanded back down, then probably it was just a bluff. And if we get enough handbacks down on an appeal, it's all going to stop. The dam is going to break.
Based on what we've read in some of the case law that you've dug up, especially that Hutchins versus Maxey Center.
We must rely strictly on history that has been accomplished already. We must believe solely on the principle of this. And we must forge forward to get our successes based on that alone. You've got to believe this, that we're on the right track. And it is, because there's all the facts laid out. And we need to persevere and break through this. And once we do, it'll be like a floodgate opening up.
Absolutely. Well, we're the first ones that you know of. So, when do the pioneers ever get it easy?
No, they don't. They don't. No, the first ones making the charge up the hill,
But that's okay.
You got to take the hill.
You got to take the hill, absolutely. And I'd say the tougher the lessons, the more valuable they are anyway. I never learned a damn thing that didn't cost me a fortune, either my own sanity or my own wallet. So
the buck's got to stop here.
Well, there's no choice. It's obvious when you get on the internet or read the newspaper, however you're getting information. What they're doing, the banks, the whole debtor-creditor side is a no-win situation. So you really have no choice at this point.
Yeah, what do you got to lose? More slavery?
Exactly. It's equity or lose more your, whatever. Lose more your goods and houses and whatever.
Right. Yeah.
Been down that path, and I know exactly where that road goes and what you end up with. It's nothing. You end up with divested of your labor and your sweat and your property, and not a whole lot you can do about it on the DC side. Not unless you can prove blatant fraud, which is very rare. You're going to get nowhere. So
yep.
We're getting there. Getting this bill going. Some of the elements of the bill, I'm looking at the trusts, the page I, and I was thinking maybe just to get the point across in the bill to set the foundation properly, just keep hammering and reiterating that a trust has been properly formed, the elements exist,
yeah.
Bam, 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 and that way a judge can't read your pleading and say, I don't understand what you're saying,
Yeah, I've been trying to find a trust case where they actually applied the trust test, so you can have some kind of comparison what the trust test was, how the court deemed it to be a trust. And it probably exists out there.
Well, I figure we already have the trust test.
Well, one that came out of the court. That's what I'm looking for. I'm looking for a case out of the court.
That's a needle in a haystack, probably.
Yeah, it might be, but it's got to be out there.
That'd be interesting to see, that's for sure. But I'd
got to
say
be some case out there in the history of the last 100 years, since 33, that shows that they applied a trust test because the trust was the question in a case, and you'll be able to see plainly what trust test they applied, how they applied it, and what the results were.
I can see what's happened to Doyle and Don. That's probably what we could expect pretty commonly as we start this thing off, is these guys saying they don't see a trust, or trying to forfeit the trust by bringing it public, or those tactics.
Yeah, but then if we pick up on it and say, okay, well, you don't see a trust. Well, here in my pleading I've got intent, purpose, party, specific, trust, res. What is it that you don't see that's not a trust?
Right. The private trust instrument expresses a definite intent to bifurcate title of the trust, res. The private trust instrument expresses a fiduciary relationship with respect to specific property.
They say, I don't see any parties. You mean you don't see any specific parties mentioned, or you just don't see the offices? Because I mentioned the office of grantor, the office of trustee, the office of beneficiary, but I didn't specifically name those parties. Would you like to see the specific names of those parties? And if you said yes, well, motion for an in-camera hearing, because that's the only place I can reveal the confidentiality of the trust.
Exactly. They are ascertainable under certain conditions. Well, it looks like whatever they counter with is simply just an opportunity to bring them back into chambers. It's just another reason for you to say, well,
Yeah, an opportunity to bring it back to that there is a trust. They have not proved anything counter that there isn't a trust.
Right. Like you said last night, they're going to say, what was your example? You don't have a car, or they're just going to make a sweeping generalization without an SOI.
What they're trying to do is get you to argue the debt, and you should be getting them to argue your trust.
Mm-hmm.
And they're good at getting you to argue the debt, and you never get them to argue your trust.
Right. Well, the good way to counter them trying to argue the debt is go back to especially a bunch of those elements that you listed off the nature of deposit call. One really good one that stands out is there is no debtor-creditor relationship between a bank in which a special deposit is made, and your pleading is specifically stating more than once that a special deposit was made. So right there and then you can shut down his DC argument, focusing on the debt. So, yeah, that.
You suppose that it's not a special deposit when me, the grantor in fact, who made out the special deposit, is testifying here and now, competent fact witness, that it is a special deposit. Who are you? Are you a competent fact witness?
And are you...
See that you can swear to under testimony on the stand that you know by firsthand knowledge that it's not a trust.
Right. And how can that judge sit there and make a determination as to what my intent was?
Only based on what you say and what the plaintiff says, and whoever's statements on the plate last. That's what's going to stand.
Well,
So all your statements are unrebutted on the plate last, because the plaintiff's got his statements on the record unrebutted. They're going to stand.
Right. Look, the way I see this playing out is just to keep a very, very narrow focus. Just to focus on your pleading. Everything should be in there, and do not let them knock you out of that focus space. Cool. You're getting there.
Okay. Anything else?
No, that was it, CW. Thanks for your help.
All right.
Great questions. Next caller, Housemark. You have been unmuted. Go ahead with the question.
Hello. You can call me Carl. I have a question that has been bothering me all day, and it's about the deed of trust that they use in Georgia, where the bank in breach right away kind of does a deed in lieu of foreclosure that they call a deed of trust, and making themselves the beneficiary, forcing the grantor into the debtor-creditor side. I'm wondering if there's a way to use, because I don't understand these pleadings yet, the administrative process. I heard you talk about it being used ineffectively in the at-law side, but can it be used in the equity side? And can a trustee in a family trust represent the grantor in this action?
Okay, what was the first question?
All right. The whole thing seems to, the issue I think is that if the bank has done a deed in lieu of foreclosure that they call a deed of trust in a non-judicial state, then we can't come back at that with from the beneficiary's viewpoint, because the bank has kind of set themselves up that way in the at-law version of this deed of trust.
Yeah, per the security or the mortgage.
Right. So is it still the same process where you're going with your pleading and you're just saying, well, the trustee, whoever that is, whoever that's been moved around from servicer to servicer, we don't even necessarily know who that is, but it's somebody. Somebody's collecting the money or was collecting the money. So that's the person that is alerted that or sends in the lis pendens or does some kind of an action that is their repudiation, and then that entity is getting rebutted and told that they're acting in breach of their fiduciary responsibility. I guess my question is, can someone who is not competent, I would say, or not capable, be represented by a power of attorney, a trustee in a family trust? How would you set that up so that you could do the work for that person?
Well, that security agreement that they've got gave them the power to come in with the warranty deed and do the sale on a default. So that's your main problem. But you're the one who created the security agreement. You're the one who gave them that authority. So if you wanted to, you could go do back a debt validation on that and then come in with that. When they didn't answer the debt validation, you got them in a dishonor, which comes back to the he who comes into equity must do equity. And supposedly they're doing a foreclosure under equity, although they're not in the course because you say Georgia's not a judicial state.
Right. They can just take the house in 30 days.
Right. So your problem is you got to negate the contract by debt validation and come in with some unclean hands, being not the unclean hands doctrine, but he who comes into equity must be doing equity. And then you need to come in and get an independent action going with them in court, get this into court so that you can bring in a stay and put a freeze on all this stuff.
Okay, so if they've already done a lis pendens on the settlor of the trust, the grantor of the trust, can the grantor appoint someone as a power of attorney or as a trustee of a family trust to do those actions for him?
And who would you appoint?
I don't know. They could appoint me. I don't know.
And then what would you do?
Then I would act as if I was the grantor with the powers of the grantor.
And do what?
And do the debt validation, do the bill in equity, do the counterclaims, ask for the stay, make the counterclaim of breach of trust, establish the express trust with the elements.
Yeah, that's what I would do. Yeah.
Okay. So that's possible to do that. I mean, has anyone else done that? I'll put it that way.
Warranty deed, is that the one you're talking about?
This is a deed of trust.
Okay, who is the
owner of record is a trustee.
Yep, that up there. Do they have the specific parties named in that deed of trust?
The specific party in the deed of trust is the trustee. Yes, it's named and recorded. My problem is there's three trusts here. There's the express trust where the grantor created this relationship and had an intent, but it was misconstrued. Then there's a family trust that overlays that was done for estate planning purposes. And then there's a deed of trust, which is another trust, but it's on that law side. So I've got three trusts, three trustees.
Right, yeah. So
it's making my head hurt.
One is written and recorded in the county, right? The deed of trust?
The deed of trust is recorded, and the
family planning trust then is
recorded.
It's recorded.
Yep.
Okay. Now then, the one that's underlying the whole thing is the one that the mortgage was formed with, but it was not
expressed. I'm not trying to step on your line, but I'm trying to understand this in a way that can make it work.
So the property is being held in the family trust?
Yes.
And it defaulted, and then they did the warranty deed in their name. You said they did a lis pendens?
There was a lis pendens done initially before I found out about it. And when I was transcribing
the documents there, whether or not they're allowed to file a les pendens, because I think a les pendens is that there is a judicial act against the property. If there is no judicial act, then I'm questioning, because they're not in court, then where's this judicial act at? Why would there be a les pendens?
That's a good point.
That might be a technicality that you could work on the at-law side to use as an injunctive force to come in with an independent action and freeze this all until something is heard.
Okay. All right. Well, you've given me some ideas, some thoughts, some ways to go after this.
And you got to get them into court in some way, and you got to bring an independent action against them and freeze it. You got to put a stay in there.
Put the stay in there before trying to establish the express trust.
Yeah, because that's first. Otherwise, they're going to sell the property right out from under you.
Okay.
The at-law side does not stop it until you get an at-law side stay. Then it keeps on running on.
So you need that injunctive action.
Yeah, you need an enjoining action to stop it. And
all right.
That pendants idea might be what you might need to bring it in as one of maybe several other points to make that.
So we would do the lis pendens from the grantor side so that we're saying there's an action against the property. Yeah. Usually the lis pendens goes the other direction.
Well, a lis pendens is just a notice that there's some kind of legal action on a piece of property. And
I understand that, but it's
everybody else that they can't be transferred free and clear. You need to go check on it.
Right. So we want to do that from this side, whereas normally it would be a bank notifying an owner in default that there's an action on the property. This is the same effect, but coming from the different direction.
Right. Right.
Gotcha. All right.
And an action in court. Yeah.
And an action in court.
And then you could file a lis pendens on your part.
Oh, so the lis pendens is not the action. It is.
No, and lis pendens is just a notice that there's a court action on this proceeding on this property.
All right. I apologize for not being clear on my question, but you've helped me tremendously. Thank you.
All right, you asked a couple other questions there too, didn't you? I forget.
Well, I think you've answered everything that I had, and one of the underlying questions was, can we use an administrative process in the equity side? And I think you already said that, yes, you would start with a debt validation and you would go with some indication that there was a default or a lack of honor, and I don't have the terms exactly right, but when I transcribe tonight's call, I will have them. I'm just wondering if the person who is either the power of attorney or the person who is the trustee for the family trust can do those actions, especially if the settlor or grantor of the underlying private trust is incapable for whatever reason of handling that, and that's why they've established a power of attorney or a trustee.
Yeah, that might be, but then you're the one that created it all, whoever was the owner of the property, so to speak. They're the grantor, that party should be able to revoke or fire, especially after you got a debt validation and certified to be in a dishonor. Now, some grounds to revoke your signature or rescind your signature on the contracts, on the security agreement.
So are you saying that we want to get rid of the two at-law trusts in order to go and express the equity trust, or are you saying that the family trustee could be put put into service to help establish that express equity
because the
trust.
family trustee, he's supposed to be defending the trust. If he's not, he's in breach of trust.
Right. He's supposed to be defending the rights of that settlor beneficiary.
Right. But that's
so
really
that
not
is his mandate then as fiduciary to do what he can to protect that entity.
Yes, he should be, yeah.
Okay.
But I see two main problems. One is you got to stop the at-law side from running on out of court and selling the property. And you need to go and get a debt validation on the at-law side and get that certified as a dishonor. And then you could convert that dishonor from the outlaw side into an equitable claim for he who comes into equity must be doing equity or they can't ask for equity. And then they can't, say, foreclose on the property because of that. And the fact that the trustee's not doing his job, that's another issue. And the fact that there's less pendants on the plate with no judicial action, that's another issue. Now, these are all grounds to go in and come in with an independent action now and list those all as asking for an enjoining action, a stay, to a preliminary injunction to halt all the actions until your things that you're bringing forward here could be heard. And then I would be bringing forth the trust on the private side and getting that and converting that all over.
Okay, so the debt validation and the dishonor and those things are done through a notary presentment.
Yes, that would be under UCC 9-210A4, I believe it is.
So would the notary be able, probably could just do those online, right?
Do those online.
UCC 1 and the 3s and all of that. Those are.
Well, no, that's I wouldn't be using a UCC on that debt validation.
No, not on the debt validation. Oh, okay. But the trustee then would be doing the UCCs and the notary presenter would be doing the debt validation.
Yeah, whoever the grantor was on the original mortgage that supposedly was buying the house.
Right.
That party needs to go ahead with the private trust and build that evidence with the UCCs, yes.
Okay. All right. Well, thank you. I appreciate you helping me unravel that knot.
All right.
Have a great night.
Thank you.
Great question. All right, I think we got a repeat caller here with a question. Darren, you've been unmuted.
Hey,
go ahead.
Hey, Christian, just quick question. What he was mentioning, in order for him to come in an action, doesn't he have to have some form of a beneficial interest in the action, since equity can only be performed in persona?
Yeah, he would have to have some kind of interest, yeah.
Because if not, then he would not. There wouldn't be any jurisdiction, persona jurisdiction on his part, because he couldn't come in. He has to have a beneficial interest.
Right.
Okay, that was my only point. That was the thing that grasped me. If he was representing in whatever capacity, is that there has to be a beneficial interest, because that's really one of our major blocks to slam opposing attorneys if they're showing up to court. Because if the real party that we sent as who's acting as trustee by their duties does not show up in that court, that attorney can't testify or say anything in that action because he doesn't have a beneficial interest.
Right. Yep.
Okay. It's my only point. That was the only point I was trying to make.
Okay.
That's it. All right. Thanks.
Thanks, Darren. All right. Do we have anybody else with a question? Just hit star 8 on your phone. Here we go. Next caller. You've been unmuted. Go ahead with your question.
Hello. I called in a couple weeks ago. Last court tomorrow, And I was wondering if you could speak a little bit on pleading special matters. And I'm going into a municipal court also. I don't know if that matters.
Yeah, you might want to check on that municipal court and see whether that's a court of equity.
Okay, and I just been asked the clerk that, or how would I find that out?
Ask them and see what they say, and then make sure you double check. But it should be defined in your constitution of your state too.
Okay, yeah, in Washington. So if let's say I'm in there tomorrow, and they ask me if I'm guilty or not guilty, it's just for resisting arrest and what was it? Paraphernalia. But so someone suggested to me that I say special matters, and like what happens next, I guess is my question.
Have you put any paperwork in there?
No, I was supposed to go see the public defender, and I've been signing everything since they first took me in by grantor. I ended up having to bail out for like $1,500 total, and I signed all those bonds by grantor, and that's about all I've signed with that one. It was initially there was even a DUI and driving with a suspended license, and for some reason they managed to drop those, and they're only going ahead with
So have you done anything at all with those offers for general deposit?
I don't know. I have the ticket still. They gave me 2 tickets, and I still have those.
Have you done a withdrawal and a redeposit and changed the character and nature of the general deposits that they've put in there?
I don't think I have. I doubt it. I'm on the Skype group, so I'm hoping to get with somebody and
yeah, you're going in tomorrow into a hearing that's set on the at-law side right off the bat.
Yeah. Yeah, that's what that... Okay, I see what you're saying. All right. And so is it going to be all right to still... I mean, I'll be able to still work this process, won't I?
Anything said in open court goes on the record as testimony. Since you're the only one that's involved in it as competent first-hand witness, you're the only witness who can testify and give the facts.
Okay. All right. So I guess I will...
you can do it with a redeposit there, but, you know, what you can say in court, open court's going to be limited because you got to make it colorable enough that you don't give away the privateness of what you're trying to do. Otherwise, you'll be breaching your own trust and commingling.
So they'll probably know what I mean by special matter. Like, does the judge actually see the bail bond at all? Like, does he see anything that the things that I've signed and all that?
Problem. If you haven't taken any of those documents that there was the offers and put them in special deposits, you don't have a trust yet. Yeah.
Right. Okay. All right. Well, that clears things up a little bit more. All right. I guess I'm gonna go and do some more reading.
Yeah. You should have been doing this prior too, so that when you went into court, everything that you needed paperwork-wise was already set in place. Everybody noticed.
Yeah, I've been having a hard time with. I didn't even have a computer. I also got hit with a search warrant 4 days after the incident. I called in a couple of weeks ago, and it took everything, even my phone. Like, I'm on a friend's phone right now. I still haven't gotten around to getting a new phone, and so I've been not really even able to be doing enough studying. But I finally got everything set to where I can really dig in here. Of course, the day before, but. Keep on trucking, I guess.
Mm-hmm.
But, all right. Well, I guess I'm going to be hanging out on Skype a lot today.
All right.
All right, thank you.
Okay, folks, last call for questions here. It is 10 p.m. Eastern Time. So we'll put one more call out there. If anyone's got a question, hit *8. And I'll go ahead and unmute you so you can ask Christian a question. Anybody? Well, if we don't have any more callers, Christian, do you want to do you have any closing comments before we jump off for the night?
I just want to say that that I would urge people to start checking out those maxims more and go to some of these old equity books that you can get for free on Google search and start checking out where they're going over the equitable maxims and how they comport to the at-law side, and start building a file with those, because those are really key, those equitable maxims under equity.
You got a simple Google search?
Yeah, Google book search, and just start finding some of the old books mentioning equity, and then just go in those books and find out where they're talking about the section under the maxims, and they explain the maxims. Start building a file. I've got probably over 20 books just on equity.
Oh. All right. Well, folks, thanks so much for joining us tonight. We had a great showing tonight. We'll plan on getting back on the phone here next Wednesday night, same time, 8 p.m. Eastern Time. And if you're not going to be able to be with us, that's okay, because we are recording the show, and so you'll be able to pull that up and listen to it. Christian, thank you so much for your time tonight. And folks, thanks so much again for joining us, and we'll plan on seeing you back on Skype talk to you next Wednesday night, 8 p.m. Eastern Time. Good night, Christian.
Night, Matt. Night, everyone.
Thanks again. Good night, everyone.